Good afternoon, everyone. I think everyone's being let in to this evening, late afternoon, early evenings summer webinar. So we're going to wait a few minutes and let everyone join. So thank you for those who are on already. And again, we are just waiting a few minutes to formally kick off. Again, so we have about 70 folks online. I think we had over 130 folks register. So I'm going to give it a few more minutes before we kick it formally off. I'll give it to 5 after the hour. So for those of you who've already joined us, thank you. And again, we're just waiting a few more minutes to let everybody into the webinar.
Yes, and hello and welcome in everyone who's already here.
So I'm watching the numbers tick up. We're getting close to 100 folks. We had over 100 register. So welcome everyone. And we're just giving it one more minute to let the last folks into the webinar. And hopefully folks will still be joining us a little bit as we kick it off. Okay, so without further ado, on this late Monday afternoon in July in wonderful Los Angeles, welcome and happy summer to everyone. Thank you, Dean Dickerson, for hosting this event, and to Southwestern Law School's communication and marketing team, who has always support flawless events and engagements like this, where we can get together as a community, even though we're not all together sharing COVID with each other, which is good. We're not all together in the same room. We can still be together in the same intellectual space to discuss some of the leading legal issues of the day. And of course, today's topic is the Supreme Court's most recent and really extraordinary term that we've just witnessed. In the Supreme Court's history has been littered with successes as well as with failures. You just need to mention Dred Scott and Korematsu to name a few of the failures. And there are scholars and critics out there today that say this latest term represents one of the largest aggrandizements of power to itself that the court's ever engaged in. And time will tell whether or not they've run roughshod over women's privacy rights and eviscerated decades of administrative law, or whether or not they've hewed with greater fidelity to the Constitution. And so those are the issues that we'll be discussing today. And we have the honor of learning about these cases from Professor Luke Boso, who is one of our leading constitutional law scholars and professors. And very lucky for me, my partner, associate dean for research. While many of these sessions often involve quite a bit of dialogue between the moderator and the expert, digging deeply into the cases, because there are so many powerful cases, so many cases that you all have read about in the news and you want to hear about, that you want to get the deeper dive into from our expert, I'm actually going to be quiet and I'm going to learn and listen along with you from Professor Luke. And please type your questions into the chat. We are saving plenty of time for questions from you, the audience. And I will ensure, and so will Professor Luke, that we get to them by the end of this presentation. So please send them in as you're thinking of them, and then I'll start to go through them toward the end. So without further ado, please go ahead, Luke.
Him, and I echo your thanks to the marketing team and Dean Dickerson for hosting this and making this happen. And thank you all for being here on a hot Monday night in summer. As I'm sure you are aware by this point, the Supreme Court's most recent term drew to a close last Monday, a little bit later than normal, but here we are. And like many recent terms, this one was a blockbuster. But this term was also, I think, a little bit different, given that some of the court's most consequential decisions were in some ways less overtly focused on some social hot button issues, or if they were focused on some of these social hot button issues, the court sometimes worked in a way such that it could avoid addressing the merits of the claim, kicking the issue maybe down the road for some later juncture. And just for context, consider sort of how overtly contentious the past two terms have been. In 2022, the court ushered in a sea change for abortion rights in the United States by overruling Roe versus Wade and Dobbs. It also expanded gun rights in a case called Bruin, which we will talk about again later today. And it chipped away at the wall of separation between church and state in a case called Kennedy versus Bremerton. And then last year's term, the court ended race-based affirmative action in higher education regarding admissions decisions in Students for Fair Admissions. And it expanded First Amendment free speech and religious liberty interests under the First Amendment, while also sort of simultaneously chipping away at LGBTQ rights in a case called 303 Creative. This term, I think, has a somewhat different flavor in terms of its impact and the cases that the court addressed, but I think that the impact is no less important. And in many ways, some of these decisions might even have greater, longer term, lasting impact. Just to orient everyone, here's a little bit of a heads up for where we're heading today. Before we dive in, just a couple of themes from this term. One, and I think Professor Van Landingham already mentioned this, is just an incredible expansion of the federal judiciary's power. We'll see in today's discussion how the court, in a series of cases, kind of sees power for itself to decide enormously important public policy questions. On the flip side, the court's seizure of power for itself comes at a cost to the administrative state. So in three major decisions, the court significantly dilutes the power of agencies to promulgate regulations and to pursue penalties against folks who violate those regulations. Another major theme of the term, I think, is an expansion of presidential power. While administrative agencies in the executive branch now have less power to regulate on issues like the environment, civil rights, et cetera, the president enjoys newfound immunity from criminal prosecution when the president acts in their official capacity. And I'm going to close today's conversation with this truly monumental decision in Trump versus the United States, and we'll talk about just how broad this might be. And then finally, a third theme of this term is really the court's continued willingness to rule in ways that seem to favor conservative ideological interests in a lot of ways on issues like guns, abortion access, and homelessness. The court's rulings, while not necessarily bombshells in the same ways in the previous two terms, they really do lay the foundation for interested parties and government actors to continue pressing forward with some of these conservative causes. And we'll talk about what some of that might look like as we discuss the cases. So for my plan for today, I'm going to try to walk you through 12 of the court's most consequential decisions from the very end of the term. This is a tall order, and I'm laughing to myself because I'm hoping we can do this in a succinct period of time. There's a lot to say. So my discussion of each of these cases is going to be relatively brief. So what was the core issue? What was the holding? How did the court get there? And what might the decision mean for law going forward? And I prepared slides for each of these cases so that folks can follow along as we do this drive-by analysis. And then after we've gone through the major decisions, there should hopefully still be plenty of time for Q&A. So Professor Van Landingham is going to be in charge of the Q&A. Submit them through the Q&A function, be thinking about your questions, and we will get to them in the end. So with that, let's go ahead and dive in, so we have some work to do. So The first stop on our tour are really the court's major end-of-term decisions affecting the administrative state. And I'm starting here because in many ways, I think that these decisions are maybe the most important of the term regarding their potential impact on governance. These decisions are going to have the effect of really unleashing a lot of litigation across the country, challenging an innumerable number of regulations. And we're already feeling their effects. It's only been a week, but I will talk about a case that is relevant to what the court has done in the past week. So to get us started, Loper Bright. The background here, so for administrative law, the court in 1984 created this doctrine known as Chevron deference. And Chevron deference essentially just means that when a case gets to court challenging a federal regulation, the first thing the court does is ask, well, is Congress's intent clear? The agency is charged with enforcing this statutory provision. Did Congress make it clear what the agency can do? If not, what Chevron deference stood for was that, okay, well, the agency gets deference. They're the experts. They have technical expertise, scientific expertise, medical expertise. So as long as their interpretation of an ambiguous federal statute is reasonable, it's a proper interpretation of the statute, then they get presumptive deference on that. And courts, unless it's unreasonable, by and large, deferred to the agency's decision making there. So this was a 40-year precedent. This was an ideological decision in Loper Bright, 6-3 conservative justices in the majority, the more liberal justices in dissent, and the court finally overruled Chevron. This has been one of the goals, I think, of some conservative interests for quite a while, and now there were the votes to do it. So what the court says going forward, when there's a challenge to a regulation brought to court, no longer does the agency itself get that presumptive deference. So it's really up to courts. Courts are tasked with interpreting statutes and coming up with their best rationale. What do they mean? And the way the court gets here is to look at a very old statute, so the 1946 Administrative Procedures Act. There's language in the Administrative Procedure Act that directs courts to decide all relevant questions of law. And the court in Loper Bright says, this Chevron deference that we've been kind of kicking around for 40 years is really contrary to that statutory language. This was a departure from what Congress intended. Now, interestingly, the Fifth Circuit below had found that Chevron deference also kind of violated separation of powers. It was a impermissible delegation of legislative power to the executive branch. The Supreme Court doesn't take the bait on that. So it purely resolves this question as a matter of statutory law, rather than deciding that Chevron deference is impermissible as a constitutional matter. And that matters only to the extent that if Congress were to, should it have the political will and capital, if it decided to codify Chevron deference, let's say, there could be another challenge, arguing that that delegation of legislative power to an executive agency is an unconstitutional delegation. The Supreme Court doesn't need to decide that today. So that was the big one. And I wanted to kind of pair it with two other things that are worth noting. So on the same day as the Trump versus US decision, this, I think, lesser reported decision, Corner Post, came out. I think it was right before Trump versus US, so you are not at fault if you missed it, where the court says going forward for folks who want to challenge agencies' regulation, the statute of limitations runs from the moment that the party is injured, not from the moment that the regulation is promulgated. So that means you could have a regulation that's been promulgated by an agency 10 years ago, 20, 30, 40 years ago, and suddenly there is a claimant who claims an injury. That person can now go to court to challenge the regulation under a variety of different grounds. And when we pair it with Loper Bright, that also means the court gets to kind of take a fresh bite at the apple. There's no longer this presumption that the agency, with its expertise, knew best when it promulgated that regulation. And then paired with one other minor decision, I say minor, but it could have far-reaching implications as well, SEC versus Jarkissi. This was an enforcement case. So the SEC uses in-house administrative law judges to adjudicate disputes in which the SEC is seeking penalties for securities fraud. The Supreme Court said you can't do that anymore. There's a Seventh Amendment right to a jury trial, and that includes enforcement actions seeking civil penalties of this nature. So you got to go to court from now on. There has to be, the right to the jury offered. In effect, this likely means that there will be less enforcement actions, at least within the SEC for now. But given how many other federal agencies use this sort of in-house adjudicative process, this might extend pretty broadly. And it's less likely that there'll be as much enforcement given how expensive and timely or time-consuming it is to pursue claims through court. So a lot of regulatory violations may ultimately end up falling through the cracks. So I think that these three cases are really pretty significant in terms of what they mean for the administrative state writ large, for us to have a regulatory government that has the power to pursue violators. So time will tell. But I will say, so I mentioned that we were already feeling the effects. Last week, I believe it was on Friday, there was a case out of Mississippi, lower federal district court, that was interpreting the Biden administration's or reviewing the Biden administration's interpretation of two different federal laws. One was the Affordable Care Act, which prohibits discrimination on the basis of sex in healthcare, certain healthcare decisions. The other was Title IX, which prohibits discrimination on the basis of sex in schools that receive federal funding. And the federal district court decided, well, we don't have to rely on the Biden administration's interpretation of what sex means. The Department of Education and the Department of Health and Human Services had both interpreted that term to be inclusive of gender identity, meaning that schools can't discriminate against a person for their choice to use the restroom or locker room that comports with their identity. Healthcare providers can't turn away someone who's seeking gender affirming care. Under Chevron deference, if that was a reasonable interpretation, lower courts essentially would have been bound. With Chevron deference gone, this judge said, no, courts get to decide. And this is not a reasonable interpretation of those statutes. So a pretty early example of, I think, how far-reaching this might be. And that federal district court imposed a nationwide injunction, which is a whole separate issue that the Supreme Court has not yet addressed. But one district court judge can now have quite a lot of say when it comes to federal regulatory policy. So we're starting there. Big change to the regulatory state. The next big category of cases deals with access to abortion-related care. And there were two major cases this term kind of touching on this issue, both of which, if you read any sort of media reporting around this, may have seemed like victories for abortion access, but both offer some hints about where the court might go in the future. So the first one, this is FDA versus Alliance for Hippocratic Medicine. This, again, was widely reported in the media as sort of a win for abortion access, and it technically is. It keeps mifepristone on the market, which is one of the most widely common forms of prescription abortion-related services. But the court uses something of a judicial trick to reach this outcome in this case, and students who had me for con law, or really if you've had con law at all, probably remember that sometimes the court relies on justiciability rules to avoid deciding an issue on the merits for whatever reason. Sometimes perhaps the issue is very controversial. Sometimes perhaps the issue might be very polarizing in terms of how the court may come out. And there have been a few examples over time. And when you take on law, or if you have, you'll remember there's some hot button issues that the court has used justiciability principles to avoid deciding. And justiciability principles refer to things like, well, when you go to court, the parties have to have standing to bring the claim. The claim can't be moot. It has to be ripe. Courts don't hear non-justiciable political questions, et cetera. And so FDA versus Alliance for Hippocratic Medicine was decided on standing grounds. So you had these various doctors and medical organizations essentially arguing that the FDA's initial approval of mifepristone was improper under the Administrative Procedures Act, and its relaxed restrictions over the years were also improper. So I've noted on this slide, over time, the FDA has made it easier to get mifepristone, shortening, um, eliminating the in-person visit was a big one that happened during COVID, allowing the drug's use later in the pregnancy, et cetera. And this is a 9-0 decision, and the court finds that these associations and doctors do not have standing here. So when I teach this case next year, this is going to go in the justiciability component of the class, but their argument for standing was essentially, we don't personally use mifepristone. We don't even prescribe it in our practice currently, but we're injured based on our conscience. We may at some point have to prescribe this, and that goes against our religious beliefs. There might be financial consequences to the extent that this medication is harmful for people who take it, which will result in increased fees and costs for everyone in the healthcare system. And to the extent that that happens, there might be reputational harm to our organizations or our practice. And the court doesn't necessarily say that these aren't injuries that could be sufficient for standing purposes. They just don't see a causation component here. They don't see that there is a sufficient connection between the FDA's approval of mifepristone and these relaxed requirements and whatever sort of future intangible injuries these doctors may have, particularly with respect to conscience, because there is protections for doctors already in place who don't want to provide certain kinds of care that go against their religious beliefs. And in terms of the potential financial harm, the court essentially says, well, there are all kinds of regulations that might lead people to be sick or be injured in some way. And if we open up the standing door here, it's kind of free rein for doctors everywhere to challenge any healthcare regulation they don't like if it mildly increased costs. And so the court just found that the causal connection here was too attenuated, meaning for now, mifepristone remains on the market, accessible, et cetera. This doesn't mean that someone couldn't come back and challenge the FDA's regulations on mifepristone again in some future case. And in fact, there is a case that's already been filed where the claimants in this one are, and I forget the number now, but a few kind of more conservative states that are kind of making the same kinds of arguments that the FDA's moves here were impermissible under the APA. I think it's unclear, whether those states will have standing to bring these kinds of challenges if these individuals, doctors, and medical associations didn't. Although there is some precedent for the court relaxing some of its standing requirements when a state is involved as the claimant. So this is not, I think, resolved for all time. It is a kind of temporary fail-safe. It maintains the status quo in terms of mifepristone. The other abortion-related case that I want to talk about, this one I think is trickier, and we should watch what happens. So this was technically a preemption case. You've got a federal law, the Emergency Medical Treatment and Labor Act, EMTALA. It is a spending bill. And for folks who have not had con law, that just means that Congress has passed this law, and there are financial incentives. If states and localities, in this case, public hospitals, if they want that federal money, they have to comply with certain conditions. And so EMTALA says you have to essentially provide stabilizing treatment to patients who present with an emergency medical condition. That's the federal law at issue. Preemption deals with a situation in which the federal law conflicts in some way with a state or local law, and under the Supremacy Clause, federal law is supreme. And preemption can happen in a few ways. It can be express, meaning Congress expressly says any state or local law that intrudes on this field or is contrary in any way is expressly preempted. That's not what we have here. Instead, we have arguably conflict preemption or even impossibility preemption, where it's impossible to comply with both this federal law and the state law. And the state law at issue is an Idaho law that permits abortions only when necessary to prevent death. So the argument here is that, well, if federal law requires stabilizing treatment, sometimes stabilizing treatment might include abortion. Idaho law says, no, it's got to be a life or death situation. And the court ultimately kind of kicks it. it punts. It finds that really, cert wasn't proper in this case. And the rationale it gave was that parties' positions about what these two laws mean changed over the course of litigation, and there were some subsequent developments below in Idaho state courts interpreting Idaho's own statute. And so the court just said, at this point, we need more fact to determine whether or not there actually is a conflict, whether Idaho law actually does prevent abortions in many cases that federal law arguably might require. So again, a temporary victory in terms of the status quo. So this law was enjoined by a lower district court. The Supreme Court at one point had stayed that injunction, meaning that it was lifted and Idaho's law could go into effect. Now the stay is lifted, and so the injunction goes back into effect. So this Idaho law cannot be enforced for now, but this is going to be ongoing litigation. And there's some other states that have enacted similar kinds of laws in the wake of Dobbs, prohibiting abortion only unless death is at risk. And so the preemption question will come back. And one of the interesting things that the some of the justices in concurring opinions here said was, because this is a spending bill, meaning a state or locality, they have to accept conditions to get the money. One of the core requirements for spending conditions is that they be unambiguous. And so to the extent that there's ambiguity in the federal law regarding what a state and local hospital who receives federal funds has to do, that might be an independent basis to find that local laws like these aren't preempted because they're ambiguous. We will see if a majority of the court kind of takes the bait on that, but the foundation has been laid. I will also point out that some of the justices on the more conservative end were a little bit concerned about the interests of the fetus in this case, because EMTALA also has language with respect to stabilizing, not only a pregnant person's health, but if that person is pregnant, also stabilizing the fetus as well. And so Justice Alito in particular said, well, we can't interpret this law in such a way that would disregard the interests of the fetus. So there's some sort of fetal personhood implications kicking around in terms of how some of the more conservative justices on the court might interpret this statute. Justice Jackson penned her own decision in this case, essentially saying, what are we doing? Why are we kicking this back? We're just going to get this again. There's a law coming out of Texas, already at the Fifth Circuit, implicating the same kinds of preemption issues. Let's resolve this now so that people who are pregnant and experiencing complications or difficulties during their pregnancy don't have to wonder and worry, do I have to be airflown out of this state into another state that will actually treat me? Because there was evidence on the record in this case that had in fact happened in Idaho. So I say that this is sort of a temporary maintaining of the status quo in terms of abortion access, at least in some cases. But I believe probably next term, if not next term, the term after, either the exact same issue or a very similar issue out of another state will find its way before the Supreme Court. All right, so we're marching our way through. Let's go to our next category of cases. So these deal with gun rights. And we've got kind of three decisions this term that relate to gun rights, two specifically, and one sort of a hybrid that talks about the First Amendment. So I'll take them in that order. Garland versus Cargill deals with kind of a narrow question of statutory interpretation and agency's power. Rahimi, which you might have heard about if you've been following the news at all, this more squarely addresses the constitutional implications, the Second Amendment implications of gun regulations. And Rahimi purports to do some cleanup work after the court's 2022 decision in Bruin. So we'll take these sort of one at a time, starting with Garland. So this one deals with, again, a federal agency, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, commonly known as ATF. And this one deals with the ATF's interpretation of a 1934 statute that limits access to machine guns. And I've given you the definition of what machine guns means in that federal statute. Gun rights has sort of been notoriously difficult to legislate at a federal level. So there hasn't been a lot of statutory action to address some of the more modern problems we've seen, particularly with respect to mass shootings. And so in 2017, we had a devastating mass shooting in Las Vegas. I believe over 50 people were ultimately killed. And so there was some movement. Granted, gridlock in Congress made legislation difficult, but this is during the Trump administration, and the Trump administration's ATF issued its own rule designating bump stocks as machine guns. And so bump stocks sort of modify an existing semi-automatic weapon so that the trigger is sort of just hitting repeatedly against your finger. And I've never shot a gun, so if that's wildly inaccurate, I apologize. But go look at the opinion. The majority does a very careful job of explaining exactly what they do. So the question is, can the ATF, again, during the Trump administration, so this is a pretty conservative presidential administration, can this federal agency interpret this federal statute in this way? 6-3 decision, ideological split. Court says no. And this is kind of an example of what's going to happen now that Chevron deference is gone. The court offers really no deference at all to the ATF's interpretations, whether they're reasonable or not, of this federal statute. Instead, they do their own interpretation of this statute. And the opinions in this case just really disagree on how to do that. How do you do statutory interpretation? Both the majority and the dissent here focus on text, the plain text of the statute at issue. But they just disagree about what that text means. They look at different sources, different dictionaries, and the dissent really says, part of interpreting text is also understanding, the congressional intent. Why did Congress ban machine guns? Well, because at the time they were the weapon most capable of inflicting mass violence. That should matter now, according to the dissent. The majority disagrees. It just takes a very sort of mechanical approach to dissecting the very specific language in the statute and saying that the ATF's interpretation of it falls out of permissible bounds. So I think that this was one of those cases that could have gone either way. It is an ambiguous federal statute. Chevron deference is gone. Courts get to decide for themselves what the best interpretation is, and we had, a more conservative aligned majority kind of rule against gun regulation in this case. Again, could have gone either way. Statutory interpretation methods was kind of at the forefront of this one. The more consequential, I think, gun rights case is Rahimi. So this takes us out of the statutory interpretation realm and squarely into issues of constitutional law. This case involves a facial challenge to a specific provision of federal law. And this particular provision of federal law allows for a person to be disarmed. So they can have their firearms taken from them if they are subject to a domestic violence restraining order. But in order to take the firearms away from someone who's subject to this kind of restraining order, there are a couple of things that have to be true. One, that restraining order has to contain a finding that the defendant, quote, represents a credible threat to the physical safety of their intimate partner or their partner's child. That's one possibility. The other is that, two, quote, by its terms, it explicitly prohibits the use, attempted use, or threatened use of physical force against those individuals. The court does not address the second possibility, or when somebody who's subject to a domestic violence order could have their firearms taken from them. It only addresses the first. So we're dealing with a situation in which someone is subject to this order and they have been found to be a credible threat. So that's the only provision of the federal law that the court analyzes here. So whether or not, a family court judge could disarm someone if they've ordered them not to commit violence in the future, whether that violates the Second Amendment, that's a separate question that the court leaves for another day. So the reason this case is important is because the court clearly knows that it needed to do a little bit of cleanup after its 2022 decision in Bruin. Bruin struck down New York's concealed carry law that had been on the books for quite some time, but it did so under an originalist methodology. So the court said in Bruin, going forward, when we analyze the constitutionality of gun regulations under the Second Amendment, the relevant question essentially is whether or not history and tradition would support that kind of regulation. Is this what the framers of the Second Amendment understood the Second Amendment to permit or restrict? That created a lot of chaos in lower courts who didn't really know how to analyze that going forward. We're dealing with federal judges here. We're not dealing with historians by and large. And so it was proving complicated for judges to figure out, well, how do we know exactly if history and tradition would support this kind of gun regulation? So this gets back to the Supreme Court, and this history and tradition analysis is a little bit of a problem in Rahimi because at the time of the Second Amendment's drafting, there weren't really robust domestic violence laws. Um, Obviously, it was a very different cultural and legal time with respect to women's rights and family privacy, et cetera. And so we just didn't really have this kind of robust legal safety net for people who are victims of intimate partner violence. The court says that's okay. So one of the things it does here is it clarifies, yes, we're doing a history and tradition analysis, we're doing originalism, but when we're comparing the gun regulation to a regulation that existed at an earlier time, they don't have to be dead ringers. They don't have to be historical twins. Essentially, the modern gun regulation has to sort of comport with the spirit of what the earlier, Second Amendment era drafting, it has to comport with what those drafters would have understood the law to allow or not. But the court does say that even if kind of the purpose is similar, so let's say there was a law in the late 1800s that prohibited people from regulating firearms if they were, a convicted felon, for example. Okay, that's evidence of what the history and tradition was here with respect to this kind of regulation. But if the modern law goes further, maybe strips a convicted felon of their firearms for the rest of their lives, or imposes additional check-ins with probation officers, or whatever it might be, that might be going too far. That might step beyond the bounds of what the framers of the Second Amendment would have thought to be true. So Rahimi allows this particular federal law to survive the facial challenge, which means, for a lot of folks out there who are victims of intimate partner violence, if there is a credible threat of force that a family court judge finds to be present, that family court judge could issue this restraining order and strip the alleged abuser of their guns. In terms of other gun regulations, I don't know that this offers a lot of clarity. The court, if you've read much about this in the media, kind of blames lower courts for not knowing how to interpret Bruin. Um, but even now, the guidance that this gives, what does it mean for the law to be relatively similar? I'm not sure that lower district courts are much better off than they were before in terms of doing this kind of historical analysis. So we'll see if this helped clear things up. I'm a little bit skeptical, at least in the interim. Okay, so next on our journey, we're going to switch into free speech world for a little bit. And there were three important cases this term on free speech, none of which really broke new ground in this area, but I would say that they refined the law in various small ways. And I wanted to start with NRA versus Lulo because it sits at this intersection between gun rights and the First Amendment. So it's a nice transition. This one, the reason I've chosen to include it, so when you take free speech, or when you're learning about it as a student, there's a concept called governmental speech. So governmental speech means that when government officials speak, by and large, in their capacity as government officials, that a person can't really bring a free speech claim, arguing that they've engaged in some kind of viewpoint discrimination or subject matter discrimination. Governmental speech doesn't lend itself to a constitutional challenge. And if you think about why, we need our elected officials to be able to speak on topics of their choosing. That's why they're elected. We want them to take positions. We want them um, to speak with the public. So the question here is kind of what counts as government speech. And here you had a governmental official who, again, in the wake of another mass shooting, spoke with some entities that she was tasked with regulating, so banks and insurance companies, and suggested that those entities might be subject to enforcement actions if they do not disassociate from the NRA. This person claimed, this is government speech. We're just advocating for the policy positions that we prefer. We would love it if these entities would not engage with the NRA. And the Supreme Court says, we're not going to decide here if this was in fact government speech or coercion, but we're kind of suggesting it was coercion. This case is just important for sort of clarifying where that line is. And so if you coerce a third party, if you're a governmental official and you could coerce a third party to censor themselves, that's an infringement. That's not government speech. And so the normal First Amendment rules would apply. And the court says there's no sort of bright line test for when that line is crossed, but there are some factors. So what did exactly the government officials say to these entities, and how do these entities respond? What's the context? How much power did this person actually have over them? And so the court kicks this back for a factual determination as to whether that happened here. But it's just an interesting sort of refinement of the government speech doctrine. When does government speech go too far into effectively censoring third parties? So that's the first free speech case. The other two, I think, got a lot more media attention. Moody versus Net Choice. This case touches a little bit on, the brewing culture war over particularly conservative allegations of censorship by social media. So both Texas and Florida, in this case, passed laws essentially making it harder for social media companies to regulate certain kinds of speech on their own platforms. The specific of the laws are different, but something they had in common. One of the ways that it was harder to take down false information or take down misleading information or take down harassing information or racist posts or whatever it might be. These laws said that the social media platforms had to provide notice to the poster that their post was about to be taken down. They had to give an explanation for why, and that there was a right to appeal. So they got some procedural due process here. So these social media companies bring a facial challenge to both of these laws, that this is kind of plainly the government interfering with private speech. It's trying to affect the marketplace of ideas in the ways in which, historically and traditionally we've understood the government does not have the power to do. And so this was another 9-0 decision. But again, the court doesn't really wade too deeply into the merits. Instead, it just says that when the lower courts below were analyzing the legal issues before them, they didn't really do it right. So we had a Fifth Circuit decision and we had an 11th Circuit decision. Both circuits are, I would say, more on the conservative end. The Fifth Circuit had simply said, any attempt by Texas to interfere with, editorial decisions by Facebook or YouTube or whatever it might be, that's not really the regulation of speech. It's regulating conduct. It's regulating a business practice. And the 11th Circuit did find that this was a regulation of speech, but nevertheless upheld these laws under the government's strong interests. And Justice Kagan writes the decision and she says, no, you didn't do this right. So number one, these are facial challenges. This is a tricky concept, I think, for students to initially grasp. But when you're bringing a facial challenge to a law, that means you're saying that there is no world in which this is constitutional. This law, as applied to everyone at all times, is unconstitutional. And as applied challenge, you're not challenging kind of the facial validity of the law. You're not trying to get a court to say, we're striking this law down as unconstitutional. It can't be applied to anyone. You're saying, as applied to me, it was applied unconstitutionally. They brought facial challenges. So Kagan writes the opinion. She says, you didn't do that right. You analyzed the facts of how this relates to YouTube and Facebook and Twitter, but you didn't really think about how this might affect other social media entities. Two, the court says, and by the way, once you actually do that correctly, when you go on to then apply, our traditional First Amendment rules, we are going to say that interference with social media platforms' editorial discretion, that does implicate a free speech interest. That does implicate expression. It's kind of like if the government tells a newspaper, you have to run stories that feature both sides. there's precedent from the Supreme Court that says that's an interference with the newspaper's kind of expressive interests in disseminating the messages that they want to disseminate. And Justice Kagan also said, in Fifth Circuit, you really got it wrong on this point. So when you go back and apply our standards, we're looking at you. You did this wrong. And then third, the other big thing the court does is, both Florida and Texas essentially said the interest for regulating social media and what they post, we want to balance what's on social media. We think that conservative voices are being silenced, that liberal voices are being featured. We want to unbias social media. It's black letter law under the First Amendment that whatever the government's interests for regulating speech are, they have to be unrelated to the suppression of ideas. It can't be about the speech itself. It has to be public safety or public welfare. It can't be, we want different viewpoints featured. That's quintessentially kind of the government putting the heavy hand of the state on speech. It's the slippery slope towards authoritarianism when it comes to freedom of thought. And so these are the instructions that the court gives. So this gets kicked back. There'll now be, again, more factual and legal analysis in the courts below. This may or may not get back to the Supreme Court, but it seems for now the court is suggesting these kinds of laws are going to be tricky to survive constitutional analysis if this does get back to us. There's some core free speech issues implicated. All right, and then the third free speech issues. This also deals with social media. This one is a bit of a win, I would say, for the federal government in particular, but just government more generally in its ability to communicate with third parties to advance certain policy goals. And it's yet another example of the court kind of using principles of justiciability to avoid kind of ruling on the merits. And like in FDA versus Alliance for Hippocratic Medicine, the problem here for the claimants is standing. But the problem on standing is a little bit different from Alliance for Hippocratic Medicine because of the nature of the relief the parties here are requesting. They're essentially asking a court to issue an injunction preventing all future communications between the federal government and these social media platforms. And this is different from seeking, an injunction to prevent ongoing present harm. For example, it's harder to get an injunction to prevent future harms. So the court essentially says you don't have standing, and the reason you don't have standing is because you can't really prove that Facebook and YouTube and Twitter deleted your post or flagged your post or fact checked your post because of the government. We've got a third party involved here. These are private companies. They're not subject to the First Amendment. They're ultimately the ones who made the content moderation decisions. We don't have enough evidence to suggest that they made those decisions because the government spoke to them about it. Yes, there was evidence clearly that the government was concerned about false and misleading information regarding COVID. We were in a public health crisis, and as folks remember, a lot of misinformation was going around, and there was a real public health risk. So the federal government talked to social media about that. There was also a risk during the election about false claims disseminating from a variety of places. There's evidence to suggest that the government talked to Facebook and Twitter about that too, but that causal connection just wasn't there. And particularly because the plaintiffs here wanted future relief, a future injunction barring the government from doing this in the future, they just couldn't show that kind of concrete, particularized injury was likely to occur again. I think it's interesting when you listen to the oral arguments in this one, both Kavanaugh and Kagan, they've been in the government, and Kavanaugh in particular, he's kind of a conservative justice, but he talked about the fact that when he worked for the federal government, he talked to the media all the time. Sometimes the administration didn't want a particular story to go out, and the administration would try to convince this newspaper or journal to not publish the story. And so if this case had gone sort of the other way, and the court had erected this wall between media and the government in terms of how the government can interact with the media, it would really, I think, change a lot of the ways that the government works in terms of its outreach to the public, its outreach to news sources. And so I think that's one of the reasons that the court um, kicks this on standing issues. All right, rolling along. So I wanted to talk about this one very briefly, Department of State versus Munoz. And it's kind of in a different category from the others. It's sort of in a category all its own. But I wanted to highlight it here today because it has, I think, major implications for issues of unenumerated fundamental rights going forward. And if you're looking for kind of a through line between this case and maybe another that the court decided this term, I would say that its brethren here is probably Rahimi because they're both originalist decisions. So when I talk about unenumerated rights, that means that over time the court has protected certain rights, usually through the 14th Amendment's liberty guarantee, that are not expressly written in the Constitution. So we might think about the right to purchase and use contraception. We might think about the right to um, marriage, for example, which is an issue in this case, the right to custody and control of one's children. These rights aren't in the text, but the court has sort of read them in over time. This case kind of implicates the fundamental right to marriage in that you had a US citizen who could not live with her spouse because the government denied him a visa. So he is living in El Salvador, she's living in the United States. She's essentially arguing the fundamental right to marriage, which the court has protected in a variety of cases like Loving versus Virginia regarding interracial marriage, Obergefell versus Hodges regarding same-sex marriage. She's saying the scope of that right includes sort of this interest to live with your spouse. And the reason I wanted to raise this case, it's actually, in terms of the outcome, not that significant. All she really wanted here was process. She wanted an explanation for why the government denied her husband a visa, and she did get it. She just got it through litigation. It took a long time. So she kind of got what she wanted. This case has broader implications, though, because of the way the court talks about unenumerated rights going forward. So Dobbs, I mentioned in the reasoning, Dobbs is an originalist opinion. The court struck down Roe versus Wade because there was no history and tradition of protecting the right to have an abortion, at least when we're looking at late 1800s law. And that's what the court says we have to do. What we have to do when we're analyzing unenumerated fundamental rights, there has to be a carefully described right, meaning kind of narrowly defined. We're not going to say the right to personal liberty. That's too broad. We've got to be more specific about that. And we have to then look for an objective, deeply rooted history of protection for that right. That's the same analysis the court used in Dobbs to overrule Roe versus Wade. And it comes back here as part of why this particular plaintiff doesn't have a fundamental right that might trigger some kind of process. And so I think this is just further evidence of where the court is going as it relates to originalism and rights. We saw it in the Second Amendment for Rahimi. I think it is very much where the current court is regarding unenumerated rights protected under the word liberty in the 14th Amendment. There's a very strong dissent in this case, essentially saying that if we take this reasoning seriously, Obergefell was wrongly decided. The right to same-sex marriage, not deeply held, no affirmative history and tradition for protection of that right. Lawrence versus Texas, which protects the right for two people to have private consensual sexual relationships with each other. That was wrongly decided. There's no history and tradition of protecting that right. There were sodomy statutes on the book, etc. The dissent says, this analysis, really destabilizes a lot of our precedent, which is sort of the same argument that they made in Dobbs as well. And I think the fact that we're seeing that same kind of analysis in Dobbs here, again, in a sort of lower profile case, does demonstrate, yeah, this is where we're going. So a lot of unenumerated rights may be at risk. Contraception, that stems from the same rationale. So if a bold state wanted to severely limit the access to contraception, reasoning like this might give that state more leeway to do so. So that's why I wanted to raise this here. And then another case that kind of is in its own category. It's the City of Grants Pass versus Johnson. I wanted to highlight this because homelessness is a humanitarian problem. It affects us all, and it's especially acute problem for us who live in the West, especially in Los Angeles. We see this everywhere. And it's an interesting case because its outcome is one that, a lot of purportedly more liberal politicians actually supported. So Governor Newsom filed an amicus brief essentially asking the court to rule the way that it does here. San Francisco Mayor London Breed did the same. And so the question in this case is how can the greater policy question, let's say that, how should cities and states deal with this problem that only seems to be getting worse as the affordability of housing um, it's not affordable. It's becoming unattainable for a lot of folks. How should cities be able to deal with this? So some cities have enacted these anti-camping ordinances, which is what happened here. It prevents a variety of things, sleeping in public, overnight parking in parks, etc. And the question was whether or not the Eighth Amendment's prohibition on cruel and unusual punishment prevents the government from criminalizing person status as unhoused. And this was the argument that the dissent made. If you're criminalizing the very act of sleeping in public because you don't have a home to go to, then aren't you effectively criminalizing that person's status as being unhoused? And so this is another 6-3 opinion on ideological lines. And I'm not an Eighth Amendment scholar, so I'll I can do my best at a quick summarization, but the court essentially says the Eighth Amendment doesn't really speak to this. The Eighth Amendment speaks to the punishments that happen after a conviction. There are sort of limitations on what counts as cruel and unusual, but by and large, the Eighth Amendment doesn't really speak to substantive criminal offenses. There is one case that is a little bit of an outlier called Robinson versus California. It's an older case where the court did say there is an Eighth Amendment limitation on criminalizing a person's status. But in that case, the law was pretty express that this was an attempt to criminalize people who were addicted to certain kinds of drugs. Here, the dissent, or I'm sorry, the majority does not overrule that precedent. It criticizes it quite a bit. It notes that it's an outlier. It notes that it hasn't really been followed in the way that the dissent suggests it has, but it doesn't overrule it. And what it just seems to be saying is to the extent that there is such an Eighth Amendment limitation on the substance of crimes, it's really limited to those rare situations where the laws express. This is expressly about who you are and not what you do. The dissent makes an impassioned argument here that this is about who you are. Because when you look at the evidence about how this law's been enforced, it hasn't been enforced against people who have a home to go to. There was no evidence that this had been enforced against anyone who is unhoused. So the dissent would have looked kind of more contextually at how this is actually playing out on the ground rather than more of a kind of formalistic textual approach that, yes, as a matter of text, it doesn't say that this is targeted towards folks who are unhoused, but as a matter of practice, it is. So in part, this decision is a little bit of a dispute about how to read the relevant law and what it does. We are now heading into the final batch of cases. We're doing okay on time. And I've saved the big ones for the end. The last two cases really deal directly with the events on January 6th and the insurrection in our nation's capital. First up is Fisher versus U.S., which deals with a federal statute that provides one of the sources for some of the charges against the January 6th defendants. And then we're going to close out with Trump versus U.S., which I'm sure a lot of folks have questions about. But I'm going to turn Fisher over to Professor Van Landegem because I believe this is more your area of expertise and interest. So take it away.
Well, thank you so much. And thank you for that really incredible analysis of so many really huge and important cases. And you did it in such a summarized, succinct period of time. So my hat's off to you.
I've still got one more, so come back to me for
Yes,
Trump. But yeah,
yes, I sure will. So criminal law, yes, finally, my bailiwick as well as national security law. So Fisher involves criminal law, specifically one of our many federal obstruction of justice federal criminal laws. The obstruction of justice statutes, which I've actually tangentially written about, are actually pretty overlapping. Many of them seem to be duplicative and seemingly in need of legislative reform, like lots of criminal law. Here, the specific criminal law in question, which was used to charge and convict I mean, at least charged over 1,000 defendants that were allegedly involved in criminal insurrection against the Capitol on January 6th. This criminal law, this obstruction of justice statute, was passed after the Enron scandal that most of you who are students are too young to remember, but it was the Enron scandal dealt with unethical white collar criminals. And this law was passed in 2002 to help protect investors. I mean, people lost their entire savings because of this. The law was passed in 2002 by Congress to help protect investors from fraudulent financial reporting by corporations. Corporations, as well as some of their attorneys, ethics folks, were lying about their status and their health of their companies. And that came to a horrible, bitter end with bankruptcies and the loss of retirement savings for many Americans. So yet here it was used, why are we talking about a white collar crime statute? It was used to charge Mr. Fisher for his January 6 acts of criminal insurrection at the Capitol. So it seemingly is an inventive use by the Department of Justice of criminal law that was originally designed for a different type of criminality. But that is not a surprise, and that's what happens with broadly written criminal law, both at the state and federal level, all the time. So here, he challenged the application of the Sarbanes-Oxley provision in question to apply to him, and a 6-3 majority of 6 justices agreed with him. But we had a different type of a split on the court here. It wasn't the standard ideological divide that we saw in so many of the cases that Professor Boso just outlined along ideological lines. Here, Chief Justice Roberts authored the majority. Justice Ketanji Jackson filed a concurring opinion, and you had Justice Barrett filing the dissenting opinion, in which Justices Sotomayor and Kagan joined. And I'll do a little bit of the analysis, but before I do, the main takeaway from this case is that really it's not going to have the huge impact that a lot of the media was at first really doing some Chicken Little panicking about. And that's because Justice Ketanji Brown Jackson's concurring opinion, which is pretty brilliant, highlights that only a tiny fraction of the actual January 6 cases will be affected. So the majority did narrow the application of this criminal law statute by tethering the actual crime to objects or documents at issue in the proceeding that the defendants alleged to have obstructed. However, even this defendant, Mr. Fisher, and others like him may still be convicted of conduct related to records, documents, or objects in the congressional proceeding. This is Justice Jackson's point. If Mr. Fisher was seeking to destroy the electoral ballots, because those electoral ballots are documents. So Mr. Fisher, along with the vast majority of the over 1,000 defendants charged regarding January 6 activities, he was also charged with other conduct under other statutes. So it's not like there's going to be an opening of the jailhouse doors and a bunch of convictions being overturned here, and there's still ongoing cases. So that is the court's interpretation of this particular federal criminal statute is still broad enough to cover Mr. Fisher's alleged conduct, most likely because by quote unquote violently storming the Capitol, the violent rioters impaired the availability of those electoral certificates that Congress convened to count. We had Senate staffers that actually had to flee the building, the Capitol building, holding certificates so they wouldn't be destroyed. So we do have a nexus here to the actual documents. So while the court did narrow the government's very expansive interpretation of this white collar crime, it did so in a way that will affect few, if any, actual January 6 cases. So here's a quote from the Department of Justice. The vast majority of the more than 1,400 defendants charged for their illegal actions on January 6 will not be affected by this decision. There are no cases in which the department charged a January 6 defendant only with the issue that is at play in Fisher. So the decision did seem to be a bit overhyped by the media. And a quarter of the defendants pleaded guilty. They never pled guilty to the obstruction charge anyway. They pleaded guilty to other counts. So really it's a sliver of a sliver, to quote, I think a scholar, Professor Seligman, a sliver of a sliver of a sliver of the defendants that might be affected. But I want to mention someone else, and that would be former President Trump, because creating electoral vote slates, as former President Trump allegedly did, could still be and would still be prosecutable. So in theory, until we get to the next case, in the Trump immunity case, in theory, under Fisher, former President Trump, there's no impact on his charges. He has been charged with 4 criminal counts. Of this, including section 1512C2, which is the Sarbanes-Oxley, Sarbanes-Oxley particular statute that was at issue here, as well as conspiracy to violate the same. His alleged involvement in concocting false electoral slates does fall foursquare within the court's ruling here. But we're saving the best for last. Here are some of the richest issues for the next case. A very brief moment on analysis here. So statutory interpretation, as we see on the slide, we have the court focusing on two canons of statutory interpretation regarding, you have to read a statute in association with the words that come around it, and then you have a more specific application in it of that doctrine. So the language, though, of the statute is really darn clear. The first subsection prohibits obstructing a proceeding by tampering with physical evidence. The second subsection, which is the one that the defendants were charged with, Mr. Fisher was charged with, is a catch-all that prohibits otherwise obstructing a proceeding through means not encompassed by subsection 1. The DC Circuit, in the lower opinion that had been appealed, was broad. It said, yeah, the statute's broad, but it's not ambiguous. It's the most natural reading of the statute that this conduct, Mr. Fisher's conduct, fell underneath it. That's what the DC Court of Appeals found. That's what 14 out of the 15 DC trial court judges decided when it considered it in January 6 cases. Because the Supreme Court, as Professor Boso has alluded to in the Cargill case discussion, the court states over and over and over ad nauseum that it assumes that Congress means what it says and says what it means, and it's going to be bound by the text of the statute. So, oh, we're textualists, except when they want to be hypocritical like they were here. In the Cargill case, which about the bump stocks that Professor Boso already beautifully analyzed, Justice Samuel Alito, of course, voted here in the majority. He wrote that even though Congress might not have desired that result, the statutory text is clear and we've got to follow it, but not here. So because interpretive tools like statutory rules of construction and legislative history come into play when the statutory text is unclear. Here, the dissent argues vociferously, and the lower court found as well, that the statute was already clear. So it seems that the Supremes in the majority went to the well of statutory construction as a way to reach their desired political goals. They didn't need them. These interpretive tools were to be used when there was true ambiguity, and if there's none, the plain text controls. So I really want to save a lot of time to get to the next case and to get to our questions. We did have the majority, and I find this valid, worried about at least the overall concern, whether or not it was genuine or not, worried about the use of broadly worded criminal statutes to have them abused via prosecutorial overreach and prosecutorial abuse, which our country has a history of abusive use by prosecutors of broadly worded statutes. However, in the 20 plus years at 2002, oh my gosh, so 22 years in which this particular white collar crime has been passed, we don't have any evidence of that. We don't have prosecutorial abuse. We don't have overreach. So that being said, I think I've wrapped up this one, and Professor Boso, I will turn it back to you, and please let me know if I missed anything.
Thank you. You did that much better than I could have, and you raise a really good point. I mean, part of the concern about Chevron deference, ending as a presumptive tool of agencies' competence, is because they're like you said, that there are canons of interpretation, but even the choice of which canons to use can be a political exercise to help a particular judge reach a particular outcome. So there really is, even though the court suggests in Loper Bright that there is a best interpretation of the statute that judges are capable of reaching, there's still a lot of ways to manipulate the canons to get where you want to go. So I think that's a nice way to kind of tie those two things together. I will try to be brief because I do want to do some Q&A here. Last, but certainly not least. So let's talk about Trump
Can
versus
I
US.
interrupt real quick? We only
Yeah,
have
go ahead.
one question, and that's whether the slides are going to be shared. So I do encourage folks to please send in some questions,
And
right?
yes,
We want to
we can
hear
share
from
the slides. Yes, please send in some questions. Okay, so this is the big one. This stems from kind of the same nucleus of facts that we are dealing with in Fisher regarding January 6th and the insurrection, but this time we're dealing specifically with former President Trump and the four charges against him that the grand jury landed on here, and he is arguing that as because these actions occurred during the presidency, he is immune from criminal prosecution. And so this is an issue that the Supreme Court had never before addressed because we as a country have never really found ourselves in this kind of situation. Before, President Nixon sort of came close factually, but was kind of named as an unindicted co-conspirator, and then President Ford pardoned him. So we just never had to directly address this before. So this is a novel question. When, if ever, is the president immune from criminal prosecution? So this was, I think, this one shocked me. I wasn't expecting the court to go this far. And I'll try to just break it down quickly because I'm sure folks have questions about it. But there's essentially three categories of conduct that the court says warrant different levels of immunity. So the first category of conduct we're dealing with is conduct that stems from core presidential functions. So powers that the president is expressly given in the Constitution. And in the opinion, the court mentions the pardon power, for example. So if the president, for example, let's say takes a bribe and as a, pardon this person and I'll give you $100,000 or whatever, because the pardon is a core constitutional power vested in the president, that is subject to absolute immunity. So anything that stems from a core constitutional power is absolutely immune from criminal prosecution. And this is, I think, what was sort of shocking to me because there are a lot of things that the Constitution vests in the president regarding power. Some of them are obviously vague and the outer perimeters aren't clear, but for example, the president is the commander in chief. And I think that this was raised in the oral arguments. The dissent raises it here. Does that mean if the president orders a subordinate to take out a political opponent or a foreign leader because the president is acting as commander in chief, is that immune to criminal prosecution? I think maybe. And maybe Rachel, you might have a different take on that, but it seems like the court is giving a very broad power of immunity to a very broad category of actions that the president may have. So that's one category. The other category, so the court says that there are things not necessarily vested in the president's prerogative by virtue of constitutional text, but are still sort of within the outer perimeters of presidential power. And in those situations, the president is entitled to, at the very least, presumptive immunity. The court declines to say at this stage whether those acts are entitled to absolute immunity. Doesn't feel like it needs to decide that, perhaps sensing that it's already gone pretty big on this particular issue. This part of the opinion didn't shock me so much because there is a line of cases in this area regarding certain claims of executive privilege or executive immunity from, let's say, civil suits stemming from conduct that occurs during the presidency, et cetera, where the court says, yes, the president is immune from those things. So there is some precedent here to suggest that, at least some limited form of immunity might be warranted for certain kinds of official acts. What is, I think, a little bit shocking to me is that the court says, while this category of conduct is presumptively immune, the government really can only rebut the presumption if it can show that a criminal charge, quote, would pose no dangers of intrusion on the authority and functions of the executive branch. that seems to me like a very hard burden um, or a very high hurdle to surpass. No dangers of intrusion. And that's not really what we see in the other cases dealing with claims of executive privilege and executive immunity. In some of those cases, it was a little bit more of a balancing. What are the president's interests here? Let's say it's an interest in having confidential communications with advisors or whatever it might be, versus what's the public's interest? What are the interests of the other branches of government who might need to conduct a criminal trial, for example? Or it was more of a balancing. This seems like a very high and to me new bar to pass. Not entirely insurmountable, but a very high bar. And then the third category the court says non-official act. So private conduct. There's no immunity from criminal prosecution there. So that is where we begin. The court also elaborates a little bit. So we've got these three categories now. So what does this mean with respect to the events surrounding January 6th? Well, one, any communications that President Trump had with Justice Department officials, that's off the table. So that cannot be the basis of any criminal charge because the court says that communicating with subordinates in the Department of Justice about investigations and decisions to prosecute, et cetera, those are core presidential powers vested through the take care clause. The president has to take care that the laws be executed, et cetera. And so that's what the president is doing when they're talking to their attorney general. So to the extent that there was any allegation that President Trump spoke to Attorney General Barr at the time about an improper investigation into political opponents or whatever it might be, that's off the table. Absolutely immune. With respect to the conversations with former Vice President Pence, this was a little bit of a grayer area. The court said that typically when the president communicates with their vice president, we're dealing with an official act, but this particular nucleus of facts doesn't necessarily equate to the absolute immunity category because part of those communications involved Vice President Pence's legislative role in terms of certifying the electoral results, which was an act of Congress that created this position for the vice president. And so this is a question on remand that the district court is now tasked with reviewing. We've got an official act here. It's not an absolute immunity situation because there's a little bit of a hybrid of whether this is an executive act or a legislative act and which communications are which. And so possibly the prosecution can rebut the presumption of immunity, but again, that's a very high bar. And then finally, with respect to the private parties, the alleged fake state electors, et cetera, the court concedes that certainly some of that conduct was not an official act, but it's really up to the district court to decide. How do we know, whether or not these are private actions or in the outer perimeter of official conduct? Court doesn't say a lot other than this is always going to be very fact specific and contextual. But I think the most shocking thing to me about this decision was that the court says, and there's 5 justices who signed on to this part of the opinion, the court says that you cannot look into the motives or intent of the president. That is an improper evidentiary path to pursue. So, if you're trying to prove that part of what the president did is a private act and part of what the president did was taking a bribe for a pardon, can't really look into the motives behind that bribed pardon to then determine whether something else that the president did is is a private act or not. It, it's a pretty dramatic evidentiary limitation on what we can look into regarding the president's conduct. So and maybe Rachel, you have some thoughts on this too, but I think that this means for Jack Smith's case against the president, kicks back to the federal district court. It's going to be very difficult going forward, I think, to pursue some of those claims. Certainly, some of the evidence that he was relying on is now inadmissible or irrelevant to the claims. At the very least, this ensures that there will be no trial before the election because, as the Supreme Court said, it's now up to the district court to sort of take these categories and our guidance and determine what counts and what doesn't. And then whatever the court decides, by the way, when this gets kicked back to district court Judge Chutkan, it will inevitably be appealed. So we're looking at a very long process. And if former President Trump is elected again, he will almost certainly order the Department of Justice to drop the charges. So that would be the end of that. I think that's a little bit of a depressing place to end, only because I mean, this is a radical expansion of, I think, very certain kind of presidential power. Um, it's getting as close to a unitary executive, at least when it comes to misconduct, being shielded from potential corruption, et cetera. And it is concerning about what a future president might feel emboldened to do after Trump versus US. So I think we can end it there. And in the very little time we have left, two questions. There's a lot to get through. I'm so sorry.
Don't be sorry, Professor Bosso. That was outstanding. And I wish we had all afternoon for this. Very quickly, most of the questions are on Trump v. US. There's one on Fisher, so I'll take that one first and quickly answer it. Here's the question. What are your thoughts on Justice Jackson's concurrence in Fisher, specifically how she looks at interpretation of state statutes to conclude that, quote, it is highly unlikely that Congress intended for subsection C2, and that's a 1512, to establish a first of its kind general federal obstruction crime. First of all, I quibble with her characterization that's a first of its kind general federal obstruction crime, because there are numerous other federal obstruction statutes that also seem pretty darn broad. But second of all, my real answer, direct answer here is that it doesn't matter what Congress intended. You don't have to go to legislative intent at what, according to textualism, if the text of the statute is clear. And that's what the court says in Cargill. So, I mean, that's really the rub of this, of that case. So terrific question. Thank you so much for that, Jonathan. Alex.
I've been preparing for the past 2 weeks on this, reading these cases about statutory interpretation. It's like sometimes we're textualists and sometimes we're not.
Mm-hmm. Depending on the goal that the majority wants to reach. And that's on both, I think,
Right.
both sides of the ideological divide. Both
Correct.
sides have used that to their ends. Okay, here's a question. Thank you, Professor Ovid. RE Trump versus US. I've heard it argued by a former DOJ lawyer and scholar that Chief Justice Roberts drafted the test and the holding ambiguously with a bit of gray area. That just moved with a bit of gray area on purpose to limit the likelihood of litigation because a potential litigant would be unsure of the result. And I've actually heard the opposite argued. In light of what was presented regarding prior prosecutorial abuse of broadly worded statutes and just in general, I'm curious regarding your thoughts, Professor Bosso, regarding the intent behind the drafting of the holding in this case. She also said, thank you, Professor Bosso, for your excellent presentation.
I don't know. I mean, maybe you can jump in on this one as well. It's really hard to sort of divine the intent of the justices sometimes. I certainly do believe that Chief Justice Roberts is not politically unaware. I think a lot of his decisions over the years indicate he has his pulse on what's happening politically and is very intentional. I'll use the Affordable Care Act case as an example. He upholds it, but finds it to be, the individual mandates tax, which is a very unpopular way to uphold a controversial federal statute. So, I mean, I think he knows what he's doing. I mean, for me, the fact that the court granted cert and then waited until the very last day of the term to issue the decision was already a win for former President Trump, because it meant that inevitably there is simply no way that this trial occurs before the election. I don't know if that was a strategic move. It's hard to understand why the court acts quickly in some cases and drags its feet on others, particularly since there was a strong majority in this one. Presumably could have gotten this opinion out earlier. I was thinking like, this opinion didn't come out before the debate that week either. They waited until that had occurred. So I do think there's some strategery, to use an old term. I do think it makes it very, and this is where I want your opinion, Rachel. I don't know what's going to happen now on remand. Do you think that Jack Smith continues to pursue some of these charges or just abandons the project altogether? Or
Oh, he's not going to abandon it altogether. I don't think so. Not based on his track record. But it's hard to read the tea leaves. But I think this is going to be a bitter fight until the end, right? But going back to the substance of the case, we have some amazing, terrific questions that have flowed in. Here's one. How do courts decide if an act is official or unofficial conduct if not using the president's motives? And I'll start with that just by quickly saying there's some things that are so obvious. For example, if a president went home and assaulted and beat his wife or his partner, right? That clearly doesn't fall under any executive Article 2 powers. So it doesn't matter why he beat his wife, he beat his wife, right? Other than that, over to you, Professor Basso, on that one.
I wish I had a good answer, and this is part of why I think you know, a little bit of the hand wringing about this court's term that I've seen in the media, it is warranted given the implications of this case. It seems unnecessary to me to have created such a high evidentiary bar to look into motives when the court itself has created these categories. It doesn't give us a whole lot of guidance as to where the line is between official acts on the periphery of presidential power and non-official acts. The only thing it really says is, well, when you're trying to do that calculus, you can't look at the president's intent. It just seems a little bit gratuitous, and I was surprised that Justice Amy Coney Barrett did not join that part of her colleague's opinion. She wrote separately to say that this was unnecessary and counterintuitive because we've drawn this line. We need some way to identify when each of these categories is present. I wish I had a better answer other than it does seem very protective of a whole lot of presidential conduct in a way that I'm not sure that the court needed to go that far. I mean, one of the things that the court talks about, so it's not even a particularly originalist opinion, which a lot of the conservative justices purport to be. It's more sort of when you look back at the U.S. versus Nixon case and the Clinton versus Jones case, a lot of these cases, the court was really concerned about, well, what is litigation and what does investigation mean for the president and the country? It's going to be distracting. It's going to be humiliating. It's going to be a target. But again, in all those cases, there was a balancing that was done. Sure, some of those things might be true, but maybe the interests of justice are stronger. Here, that balancing just seems to have totally fallen by the wayside. And the entire scales are just tilted on the side of the presidency in a way that I haven't seen in any of these other cases. So that's what the most shocking thing to me was, and I don't have a lot of answers for why or what this means for future attempts to hold a president accountable, criminally speaking.
This is a related question, and that is after Trump versus United States, what are the mechanisms that are realistically available to quote unquote rein in a rogue president besides impeachment? Can executive orders still be enjoined, or can some other action be taken short of impeachment? I want to throw something in there because it's related to the last question, and you brought up, Professor Basso, the reference to, well, does this mean the president, because this was brought up some of the lower court and in oral argument, lower court amicus briefs and holding and in the oral arguments, could President Trump order Navy SEAL to take out a political opponent, that is execute, kill, murder, assassinate? And there are folks that pushed back and said, no, I mean, that's never going to happen because the military knows that they have to disobey an illegal order, which I scoffed at because military folks, Abu Ghraib, and far worse, have followed illegal orders throughout history, often with impunity. So I'm not resting on that as our protection, that our military is going to actually say no, to be very frank. But I wonder if that could be one of the dividing lines on official versus unofficial acts. If the president, in his constitutional commander-in-chief hat, orders something that is clearly unlawful, that is a crime, clearly unlawful. I mean, ordering our troops to go overseas somewhere, there may be political differences on it, such as Vietnam, but it's not clearly unlawful whatsoever. It's actually clearly pretty lawful. But ordering a military member who to execute someone in the United States, unless that someone can be there's evidence that they're an unlawful enemy combatant in some kind of armed conflict we're engaged in, is clearly unlawful. So, but regarding other ways to
That's
rein in
optimistic, and I like that because I do feel like the opinion kind of hides its head in the sand and says, we'll never get to this point, but you know, we may. And so I like that you were trying to give us some dividing lines that the court should have to have wrestled with.
Well, I think it's going to continue. I think, I mean, if we have a president that engages in actions that are criminal, we're going to have these, perhaps we're going to have these cases, and the lower courts are going to have to flesh this out, because this court did not help flesh out these categories in this opinion. But do you, Professor Bosso, feel that there's some other kind of action that can be
Oh,
taken to rein in a rogue president?
and so this is what is sort of doubly maddening about this decision in particular is because Trump versus US is an enormous expansion of presidential power, but in a very narrow sense. So it means that there's very limited criminal oversight over what a president does in their official capacity, whatever that means. So that's an expansion, quite obviously, of presidential power in a way that makes it harder to root out corruption. But in so many other cases, the court has whittled away the president's power to act in ways. I think you mentioned issuing an executive order in your question. Um, but even before Chevron deference fell this term, the court had already created this doctrine known as the major questions doctrine, which essentially had said if the president directs a head of an administrative agency to promulgate some policy or issue some rule, but that rule or regulation poses enormous political significance or financial costs, then the president has no authority to do so. And the major questions doctrine is itself a constitutional limitation rather than a statutory one. And then we've ended Chevron deference, making it harder for the president to appoint people who can make policy related to the civil health and life of our nation. So, in terms of actual powers that the president has to shape the nation for the good, a much more limited view of the presidency. But in terms of the power that the president has to engage in potentially ethically problematic or maybe even illegal behavior, a much aggrandized version of the presidency, which feels like it's a little topsy-turvy to me.
So we're gonna conclude on one last question, and this is dealing with Loper Bright. So the question, it's a terrific question. In regards to Loper Bright in combination with Corner Post, do you believe that we will see an increase in corporations incorporating within friendly district court jurisdictions, specifically to challenge existing regulations? And I'm so glad that question was asked, because that's actually one that popped
Yeah,
up during your wonderful presentation.
yeah. I mean, it's already happening. So there is a district in Texas that only currently, or not a district, it's a division in Texas that currently only has one active federal judge. It's Judge Kaczmarek, a President Trump appointee. He is the author of the original mifepristone decision that initially, at least, was designed to take it off the market. It's in Amarillo. He's the only party in town, and so there already is a cottage industry of conservative interest groups setting up shop in Amarillo precisely to bring challenges to laws and then hopefully secure a nationwide injunction against them that they don't like. So, yes, I absolutely do see this. And I'm now forgetting the body, the judicial ethics body. It's not binding, but they issued a guidance recently suggesting that in the event that there is a division with only one judge, that the circuit should find a way to randomize case assignments. And the Fifth Circuit essentially came back and said, no, we're not doing that, because we kind of like that people can form shop in this particular way. So the answer to your question is yes, I do see this happening.
And Luke, doesn't that relate back to also the statute of limitations? I mean,
Yeah,
it provides a huge
correct.
opportunity for all these things to be
Regulations that we thought were set
settled
into
law. Yeah.
place 40 years ago, right? You
Yes.
you find you set up shop in a district with
Mhm.
a judge that is friendly to your interests. You allege an injury
Yep.
that has occurred today rather than 40 years ago. Yeah, you can potentially gut that law.
On that note, I want to
There was
thank
no
you,
way this
Professor
wasn't going to be a
Bosa.
little
I know.
depressing.
And I thank everyone here for showing your dedication to the rule of law, and having been in downtown Kabul, Afghanistan, with car bombs going off around me, and seeing children with no shoes, living in the elements with armed conflict going on around them. As much as I struggle and disagree with some of these cases, I'm also still very grateful that we have a Supreme Court, that we have a rule of law that that is still working for the most part. So I just want to leave on an optimistic note. It's still working because we're still here, we're still paying attention, we're still using these avenues to fight for our values versus using weapons to fight for our values. And I would hope it would never get to that end. So I congratulate everyone here who is on a legal journey as one of our students and everyone else that's interested. And thank you so much, Professor Boso. There couldn't be a better person to have done this today. And thank you, Dean Dickerson, for the opportunity.
Thank you for being our moderator and giving us your time and your expertise. And thank you to all of you for being here. I echo everything that Rachel said.
Happy summer, everybody.
Go relax. Don't read the news
Go
for a
eat
day.
dinner. Go eat dinner.